Good afternoon, everybody, and welcome to another question and answer session. My name is Samara Belitzky. I'm a lawyer at Samfiru, Tumarkin. I practice out of our Ottawa office, but I'm here, as I usually am, every few Fridays to answer all of your questions related to employment law, workplace issues, you name it. I'm here to answer your questions. So if you have questions about constructive dismissals, issues in the workplace, changes to your workplace, conditions or employment terms and conditions, harassment in the workplace, issues with respect to vaccination policies or vaccination mandates at work, which we're starting to see less and less of, but it still continues to be an issue for some people. Now is the time. Ask your question, send your question in. As I mentioned, I'm here for the next half an hour or so to answer all of your questions related to employment law and workplace issues. If you have questions about severance, terminations, whatever the case may be, send in your questions and I'm more than happy to answer them. If there's something that's been on your mind, either for you, a friend, a family member, whatever the case may be, something you've been wondering about, now is the time. Send in your questions and we will get to as many as we possibly can. As we wait for some questions to come in, there are a couple things that I've planned to talk about today that have come up recently, either in the news or things that people are writing into us about, calling us about, that have been very commonly asked over the last little while. So in terms of those issues, the first one is vacation. So obviously it's the summer, we're the middle of July right now. Vacation is on everyone's minds, especially as the pandemic has improved. Many people are now traveling. We've seen a lot of things in the news about traveling and delays in the airports, but from an employment law perspective, there are certain things that are important to know and that we've gotten a few questions about over the last few weeks. So the first thing that I wanted to clarify is that in terms of vacation entitlements, there is a minimum amount that everybody is entitled to receive under the Employment Standards Act. So for example, if you're in Ontario, the bare minimum when it comes to employment vacation from your work is 2 weeks if you have up to 5 years of service. So 5 years of service or less, you're entitled to receive 2 weeks vacation. And that's mandated by the Employment Standards Act. That's non-negotiable. It's a bare minimum and you have to receive that. Your employer has no choice but to give you that. The question as to when you take vacation is another issue, which I will get to. But generally speaking, that's a minimum of 2 weeks. Once you hit 5 years of service or more, then the minimum becomes 3 weeks of vacation. Now, in terms of your actual vacation entitlements, that's just the bare minimum. Employers can provide you with more than that. So oftentimes we'll see people who are owed, they have 5 years of service or more, they're owed 3 weeks as a bare minimum, but they've worked for an employer for maybe 10 years and they currently have 4 weeks of vacation or even sometimes 5 weeks of vacation, depending on the situation. Similarly, sometimes we see people who have under 5 years of service have an entitlement to 3 weeks because that's what the employer has offered. So an employer does have the ability and the discretion to offer more. But the bare minimum does start at 2 weeks for under 5 years of service and 3 weeks for over 5 years of service. Now, in terms of when you take your vacation, that's a question we've been asked a lot recently because so many people, now that the pandemic is improving, are wanting to take their vacation that they haven't taken in so long and travel and do the things that we've all been waiting to do for so long. In terms of when, that's actually at the employer's discretion. Now, most of the time when employees request vacation, it's approved. As long as there's no issue, it's not a time of year that would cause a serious issue, it's approved. And so because of that, most of us as employees think that we get to decide when, because usually it's approved. But the way the law actually works is that employers do have the discretion. So employers do not have to approve vacation as it's requested or when it's requested. And employers actually do have the right to dictate when an employee can take that vacation. So when it comes down to it, absolutely, you have the right as an employee to take a vacation. And as I mentioned, it would be in the amounts that we discussed, the 2 weeks or the 3 weeks as a bare minimum. That's a starting off point. But the employer does have the ability to decide when you take that. Most of the time, this doesn't come up as an issue or a problem. The parties, employees, employers can work together, but it does come up sometimes. And at the end of the day, the employer does get to decide when that gets taken. Now, coming to kind of the last issue with respect to vacation that we get a lot is a question about vacation pay and how that works. So when it comes to vacation, there is no specific law about whether it has to be paid or unpaid. So what that means is that as long as you get your either 2 weeks if you're under 5 years of service, or 3 weeks if you're over 5 years of service, that's the bare minimum in terms of getting to take that time off. Whether it's paid or unpaid is a different story. So employers have two options when it comes to these entitlements for vacation. You can either have a situation where when it comes time to take your vacation, it's unpaid, but throughout the year, on every pay and paycheck that you receive a percentage of your pay as vacation pay. And what that's meant to do is it's meant to make up for being unpaid during that vacation. So it's vacation pay that you can put towards when you're actually off work not being paid. And the amount will vary depending on your vacation entitlements. So if you're someone who's entitled to that bare minimum 2 weeks and nothing more, then it would be 4% on each paycheck. If it's 3 weeks, it would be 6%. If it's 4 weeks, it would be 8%, and so on and so forth. And so if your vacation is an unpaid one, you still get to take it. You have the right to it as an employee. But if it's unpaid, then you get the percentage of pay on each paycheck. And the amounts, like I said, will vary. Alternatively, the other option is to have a paid vacation. If you're an employee who receives paid vacation, that means when you take the time off, you're being paid as if you are working. So you're getting the exact same pay while you're on vacation as if you were at the office or working at the workplace. And in that situation, you would not receive a percentage on each paycheck because you're getting paid during your vacation. So you would get your regular compensation, but you wouldn't get extra vacation pay on top of that because you would receive it when you take your vacation. So I hope that clarifies things for most people. These are the types of questions we get a lot about vacation. There seems to be a lot of confusion about vacation in terms of who gets to decide when to take it, how do I get paid, do I get paid? All of these issues rightfully are coming up right now as people take more and more vacation. So hopefully this provides some clarification on that issue. If you are having any issues with respect to vacation or you have any questions, feel free to send them in now, or you can always contact us at a later time. If, let's say, something comes up in a few weeks, you can call us, and the number is on the screen right now. You can also email us at help@employmentlawyer.ca. You can also go to our website at employmentlawyer.ca and go to our contact form on our website, or you can contact any one of the lawyers that we have on our website. My contact information is on our website. If you go to our website and you click on my profile, all of my information is there. So you can always contact me directly or anybody else at our firm for that matter. So I've tackled the vacation issue, which is one of the things I wanted to talk about today. We did get a few questions in while I was addressing that. So I'll get to some of the questions here, and then I'll get back to my list of topics if we have time before this is finished. So I have a question. I have a question from Ellie on Facebook who says, in response to equal work, equal pay, can an employer hire a subcontractor to do the same job you're doing and pay them more than they're paying you to do the same job? Likewise for other male colleagues. Okay, so that's a second question. And how do you approach a discrepancy in pay/pay discrimination issue with your employer? All right, Ellie, thank you very much for the multiple questions. This is a loaded one, so I'll address each piece of this kind of separately here. So in terms of equal work, equal pay, it does only apply to employees that you are working with, so your colleagues. If an employer is outsourcing and hiring a subcontractor to do the same job, there are a lot of other factors at play there. So it's not a salary in that scenario, or at least theoretically, there wouldn't be a salary, a fixed salary like you would be receiving. The subcontractor likely has an arrangement with your employer. There's a contractual transaction that has taken place where an amount has been negotiated. So it's hard to say, when you compare work to work, what is exactly that they're being paid for and how much, depending on the contract and the details. That's in a true contractor relationship. So if they really have done that. If, for example, the person who has been contracted to do this work is not really a contractor and is actually an employee, they might say that they're a contractor on paper, but in practice and in reality, they're actually an employee. That's different. So then the equal work, equal pay may come into play at that point. Because it's being disguised essentially. And this does happen a lot where employers will treat people who are actually employees as contractors. And I've seen it time and time again where somebody works for a company for years. They're always treated like a contractor. They're paid like a contractor. Maybe they've signed an agreement that says independent contractor agreement. But that doesn't matter. That's not what we look at in order to determine the status of a worker. We look at the actual situation. And if this person is acting like an employee, if it looks like an employer-employee relationship, the employer has control over this person when they do their work, how they do their work, the scope of the work. These are all examples of things that provide us with an idea of the degree of control that an employer has over that worker. If it looks like an employee relationship, it likely is, notwithstanding the other things I mentioned, like how they're being paid. So if, let's say, that's the case, and it's essentially someone doing the exact same job as you under the title of contractor, but they're not really a contractor, and they're being paid more, that could be a situation where your employer is breaching the legislation related to equal work for equal pay. And that's something that absolutely you can address if it does fall under those provisions. Now, with respect to your question about male colleagues, similar. If there's a male colleague doing the exact same job as you, exact same title, same experience, same duties, everything the same, you're female, they're male, and they get paid more than you, that's an issue. And certainly that can be addressed. That's an issue for two reasons. And you've mentioned it in your question, Ellie. The first is there's an equal work, equal pay issue there. And the second is there's also potentially a discrimination issue. I say potentially because the fact that the colleague receiving more pay happens to be male doesn't mean that it's because they're male and you're female. It's possible, but doesn't mean it's absolutely the case. It could be for other reasons. Maybe that person is friends with someone in management. Maybe there's nepotism going on where they're a family member. There could be so many different reasons for why that person is getting more. Maybe it's an error. It's hard to say. At the end of the day, when we're looking at discrimination and we're wanting to look at allegations of discrimination in the workplace, there has to be an element of it being proven that it's because this person is male that they're getting more money than you, and that on the flip side of that, as a female, you're receiving negative differential treatment because of your gender, because you're female. And you can reverse those things too. It doesn't have to be, it could be a male getting paid less than a female and vice versa. At the end of the day, if you're being treated differently in the workplace because of your gender, that would be discrimination. And it doesn't have to be only because of your gender. It can be part of the reason for why you're being treated differently. As long as it's part of the reason, it would still meet the threshold for discrimination. So again, it doesn't have to be, when we're looking at discrimination, it doesn't have to be the whole reason for why somebody's being treated differently. It can be just part of the reason or one of the reasons. And to expand on that a little bit, when we're talking about discrimination, Under the Human Rights Code, there are several grounds that are protected. So sometimes differential treatment or discrimination, even though it might be unfair, is not necessarily illegal. It's illegal if it's on the grounds of one of those bases under the Human Rights Code. For example, age, disability, ethnicity, sexual orientation, gender identity, gender. So these are all different situations where these types of grounds are protected by the code. So if you are discriminated against or treated differently because of one of those grounds, and I haven't mentioned them all, there are others that I haven't mentioned under the human rights legislation, then if it's on the basis of one of those grounds, in whole or in part, that would be discriminatory conduct, and that would amount to discrimination. So that's where you have to look at the whole situation. And if you are in a situation where you feel like you're being discriminated against on a code protected ground, then you should absolutely reach out to a lawyer and discuss the situation and see what your options are. Because oftentimes what happens is you don't do anything about it. And then maybe a year later, you're let go from your job. And then you want to do something about that discrimination from a year ago or more. The challenge is time is of the essence with these issues. And specifically when we're dealing with human rights issues, you have a year from the last date of discrimination to pursue these things. So oftentimes, by the time someone contacts us about something that happened in the past, it's too late to pursue. It's too late to do something about it, which is why we always tell people, when you are dealing with the issue, contact us right away. Get in touch with us. You need to get advice from an employment lawyer right away on these issues so that you know where you stand, you know what the law says about your situation, and you can figure out what best to do moving forward and take advantage of the legal recourse that might be available to you. Otherwise, you might lose the ability to do that. Okay, so I'm going to go back to Ellie's question. Like I said, it was a loaded one, and I want to make sure I provide comprehensive information on these various issues. So if you are in a situation where you feel like you're getting paid less because of your gender or any other code protected ground, absolutely that should be addressed, because that is something that doesn't just fall under equal work for equal pay, but it also could fall under a human rights issue and discrimination. Now, in terms of addressing it, I would actually recommend that you speak with a lawyer before you bring it up with your employer. If it's something as simple as, this person is making more money than me for the exact same job, that is something that you can likely raise on your own. If you're going to do it on your own, you make sure you do it in writing and you do it in an email, because then you have proof of it being sent and received and the fact that you raised it. Something of that nature can be addressed on your own. Hopefully it gets fixed. If not, that's when you would go see a lawyer, and I would be more than happy to help you, Ellie, or anyone else in this situation. If you think there's a discrimination issue at play, if you feel like you're being discriminated against for any of the code protected grounds that we discussed, that's when you should be going to see a lawyer, because you want to make sure that you don't do or say anything that could cause harm or prejudice your legal position. You want to get into the strongest legal position possible and understand what it is that the law says about your situation to make sure that you have all your ducks in a row moving forward. And the best way to do that is to speak with an employment lawyer, get in touch with us. We can discuss the situation, in detail, and let you know where you stand and help you, guide you through the next steps. Oftentimes, I do speak with people in situations like this where they're dealing with this situation at work, and I'm behind the scenes, helping them, guiding them behind the scenes, telling them what to say, telling them what to do, because it's not every situation that you need a lawyer to be involved and to be dealing with your employer on your behalf. That does happen a lot of the time, but sometimes you can deal with it on your own with our help in the background. And this is the kind of situation where that would be appropriate. So that's what I would recommend if there is a discrimination issue, because there's a very specific way in which it needs to be addressed with very specific language. And we can assist you, and any employment lawyer should be able to assist you in making sure you do and say the right things to protect yourself moving forward. So I hope that answers all of your questions, Ellie. Like I said before, this is a loaded one. There's a lot of moving pieces here. So if you are dealing with an issue of this nature, I always recommend doing your due diligence, getting advice from an employment lawyer so that you know where you stand, because there's nothing worse than sending an email or doing something that's going to potentially hurt your case and then regretting it after the fact. So it's always better to be proactive and get that advice first, so that you make sure you're taking all the right steps. I have a series of questions here that have come in from George on YouTube, so I'm going to go through this. George says, I've been working remotely for the past 2 years due to COVID. The employer is now implementing a hybrid model with 1 day working at the office and 4 days from home. The employer announced a mandatory vaccination policy. I expect to be dismissed with cause because I'm not vaccinated and don't intend to become vaccinated. I've signed an employment agreement waiving my rights to common law severance. Is it worth pursuing constructive dismissal? And then George also says, additionally, if you are able to assist with asking employer to change the reason for issuing the ROE, the record of employment, to a new code, what would this new code be? Okay, so in terms of this issue, a few things. So when we're talking about remote work and going back to the office, this is an issue that has been coming up a lot lately, because right now and over the last couple of months, a lot of employers are calling employees back into the office. So as an aside, it's important to know that if the terms of your employment were that you worked at the office every single day before the pandemic, those remain your terms of employment unless your employer has made a change. So what I mean by that is I've heard from people over the last year or two where during the pandemic, the employer decided from now on it's going to be remote work or hybrid work. That's a permanent change that we're making. They did it in writing. They sent a letter to the employees saying, from now on, this is your new terms of employment. You're going to be working from home or hybrid, half-half. That's a permanent change. So in that case, if the employer then wants to go back to 5 days a week in the office after making that change, the employees do not have to comply with that because the employer permanently changed their terms of employment to remote or hybrid. For most people, the employer has not done that. For most people, the employer has done a temporary change because of the pandemic, and now they're wanting people to come back to work. If you're in that category as an employee, you would have to go back to work. You don't have a choice in saying, I prefer to work from home if your employer wants you back at the workplace. If you can figure something out with your employer, come to some sort of arrangement, great, but they don't have to allow you to do that. Unlike in the Netherlands, where we recently learned that remote work is going to be a legal right moving forward. That's not the case in Canada, at least not yet. Maybe we'll see it in the future, but for now, there's no legal right to remote work. And so it is based on what your terms and conditions of employment actually are. If you don't go back to work or go back to the office and you're supposed to, that would be a resignation. And then as an employee, you wouldn't be entitled to any severance pay or any other amounts except for any pay that you've earned up to that date. So that's really important to know. If you're dealing with this issue right now, get in touch with us because we can look at your situation. Every situation is different. As I mentioned before, some people have to go back and they have no choice in the matter if they want to keep working for that employer. And then in some circumstances, if the employer has actually made some permanent changes, that's where you might be able to push back on having to go back to the office. So in terms of your situation, George, if you were working before the pandemic 5 days a week in the office, the employer certainly has the ability to say you have to come back to work and we're doing 1 day at the office, 4 days at home. They would have the ability to do that if they wanted to. However, when it comes to the vaccine mandate or the vaccine policy that they've put in place, that's something that you can push back on. Now, at this point in time, a lot of employers have already suspended their mandatory vaccine policies, following in the footsteps of the provincial and federal government. At this point, certainly we've seen a lot of companies walking back these mandatory vaccination policies. Having said that, there's still a lot of employers out there who have them in place. Now, if you are put on an unpaid leave or terminated for cause because you're not vaccinated in the face of a mandatory vaccination policy, you have legal recourse. You can fight it, and we can help you with that. We have lots of cases that we are assisting people with for this exact issue. You are owed severance if you're being terminated for cause because of a failure to be vaccinated. That's not cause for termination. Cause is something that is very hard to prove, and it means that the employee has engaged in serious misconduct. So serious that the employment relationship just cannot continue. That would be something that the employer would have to prove in order to substantiate that they had cause to let someone go and pay them nothing. Now, in the context of these mandatory vaccination issues, the employer is going to have a very hard time proving that an employee not wanting to be vaccinated was cause, okay, and that they're owed nothing upon termination. Secondly, as an unpaid leave, an employer doesn't have the right to put somebody on an unpaid leave, not allow them to work, and not pay them. That would be a constructive dismissal because the employer is not telling you outright that you're fired, but the end result is the same thing. You're not working, you're not getting paid. So you have the ability as an employee to treat that unpaid leave as a constructive dismissal, as a termination of your employment, and to pursue severance. So in those scenarios, you have those options. So for you specifically, George, if you're let go, you said you expect to be dismissed for cause. If you're terminated for cause, you get in touch with me right away. I'm more than happy to help you in pursuing what you're owed, okay? Now, in terms of what you're owed, that's when we get to your next question. You say you've signed an employment agreement waiving your rights to common law severance. You may think you've done that, but we would have to review that in order to be sure, because oftentimes what happens is employers will put language in an employment agreement where they try to limit your severance rights. They try to limit you to just the bare minimum, like, George, you think they've done here, but it takes very, very specific language in order to do that successfully from the employer side. And unless it was drafted by an expert employment lawyer very recently, it's very likely that it doesn't do what you think it does. It's very likely that you've actually maintained your right to common law, to your full severance, even though you've signed that. So it's really important, even if you think you've abandoned that right, get in touch with us. You can contact me directly, George. My information is on our website, employmentlawyer.ca. More than happy to look at your employment agreement, let you know if it does limit you or not, and go from there, because the odds are it doesn't limit you. 9 times out of 10 in a situation like this, the language used is not sufficient. So that's really important to keep in mind for you, George, and for anybody else watching who thinks they're in a similar situation. Lastly, you've said, is it worth pursuing constructive dismissals? So a constructive dismissal would be in the scenario I explained. If you're put on an unpaid leave, that would be a situation of a constructive dismissal because your employer is not outright saying you're fired, you're terminated. If you're let go for cause, that's not a constructive dismissal. That's an outright dismissal. That's a termination. So in that situation, it wouldn't be that you are pursuing a constructive dismissal. It would be that you're pursuing severance. And it would be a wrongful dismissal because you've been let go and they did not provide you with what they should have, assuming they don't give you any severance. Okay. Lastly, we're just getting to the end of our time here. I know you had one last question, George, about the record of employment. So unfortunately, for people who have been either put on an unpaid leave or let go because of their refusal to be vaccinated, the federal government has been very clear in advising employers of what code and what commentary to put on records of employment. Similarly, they've advised Service Canada not to approve any EI or employment insurance benefit claims if the person was put on leave or let go because of their refusal to be vaccinated. So getting around that is unfortunately very difficult. We have been able to assist people in doing so. I have had some clients who have been approved for EI, notwithstanding the fact that it's a vaccination issue and the vaccination or the lack of vaccination is the reason for the application for EI. But it is difficult. So in terms of the record of employment, certainly, we can negotiate, a different code on your record of employment. I don't think it's something on your own, George, that you'd be able to negotiate successfully if you're let go. It is the kind of thing that we can negotiate as part of a negotiated settlement for you if we're able to go down that road. The regular code for a termination is either code A for a layoff or a restructuring, or code M for dismissal. So on the record of employment, there's no distinction between whether it was for cause or without cause. It's code M for dismissal. That's what most employers will put for a regular termination or a termination for cause. And then sometimes you'll put code A for a layoff or restructuring. If it's a without cause termination, some employers will use that code as well. Either one of those codes usually will mean you'll be eligible for EI benefits, barring anything exceptional. So for that, I'd say, George, or anybody else who's dealing with this issue on the records of employment, if you'd like assistance with this issue particularly, get in touch with us. Like I said before, we've assisted people with this issue over the last few months, or even longer, I should say, since last fall. And sometimes employers are willing to negotiate on this issue and sometimes they're not. But there are ways around it, and we have been successful in getting people EI, although, like I said, it's quite difficult given what's happened with the federal government directives. So we'll leave it at that for today. We're just at the end of our time here. I see I have a couple other questions. If we didn't get to your question, we have other question and answer sessions next week. We have one on Monday at 3 p.m. We have others during the week next week. And you can also write into us at help@employmentlawyer.ca if you'd like to send your question in by email, and somebody will get back to you. So thank you very much, everybody, for joining today. And I hope that everyone has a wonderful weekend.